This is an area where there's a lot of scrutiny right now, executive compensation. The list goes on and on of organizations that are being questioned about their executive compensation practices. And it's all over the tax-exempt and for-profit sector. We've got American University, there was the Smithsonian, there's certainly large organizations like Alina Health. The list goes on of organizations that are being questioned about the board's oversight of compensation. So this one's important to pay attention to. Members of the audit committee must be independent. I think that should be independent. There's nothing that states in anything that we've read so far from the IRS, for instance, that the audit committee must be independent. On the other hand, under Sarbanes-Oxley Act, which we're not part of, those of us who are in tax-exempt organizations, we don't have to abide by Sarbanes-Oxley, but in that realm, all members of the audit committee must be independent. And most advanced organizations that we know of who are in the tax-exempt sector are intentionally making sure that every single person who oversees the audit is independent. And I want to parse that out a little bit further. I've been with a lot of boards recently that have combined their finance and audit into one committee. I think that's potentially not a good thing. I don't want to be hyperbolic. What is that word? I don't want to be too expansive on this. I think it's easier and probably better practice to separate out your finance committee from your audit committee. Go ahead and put a lot of different kinds of people on your finance committee. Use it as a pool of people that you're trying to teach about governance in your organization. Maybe it becomes a pool of people who serve on your board. Keep the audit piece as a separate committee and make sure they're all independent. And then you don't have the problem of the same individual sort of trying to oversee the exact function that they're sitting on. The third point talks about the chair and the majority of the governance committee members being independent. That again comes out of Sarbanes-Oxley, and therefore the for-profit realm. You can choose whether or not you're going to have your chair of the governance committee be independent or not. If you're looking to be beyond reproach, as Lucian said, if someone goes on to the 990, the IRS Form 990 that your organization submitted and sees the names of the people who are serving on your board and start to wonder who chose those people. Were the governance committee members all independent who chose those people? Or was there some influence in terms of who would actually be serving on board? And another idea would be a disabling guidelines board policy. And this is something that we're seeing more of. I would say that there aren't that many organizations out there yet doing this, but I think it could help. And that would be that as a board, you would decide, are there certain situations that are so severe a conflict of interest or potential conflict of interest that the person probably shouldn't even be serving on the board. And an example of that might be a deliberate violation of a conflict of interest or confidentiality. There was a real example of a physician chair of a board of a hospital and health system who just never mentioned to anybody that he was investing in a competing hospital nearby. One of the other board members found out about it through the community and called this gentleman on his behavior, and it wasn't pretty. What they ended up doing is finding a way to gracefully move him out of the chair position and off the board. They then wrote a policy that said, if you are an owner, partner, employee, board member, or investor in a direct competitor of our organization, it's going to disable you from being able to serve on our board. Just period. If you have a family member who's a senior executive officer for the organization, if I have a daughter who's the CFO of the organization on whose board I'm sitting, then I would be, according to this policy, I'd be disabled from serving because there's this inherent conflict. My daughter, I care about my daughter's the CFO, supposed to be overseeing the finances of this organization on whose board I'm sitting. These are just examples, and if you're interested, I can give you some articles that will give you more examples, but the concept I want to leave you with is I think it's okay, maybe even helpful, to figure out, are there certain things that are so difficult for us to manage? Would we have to recuse that person so many times that really we've just left ourselves an open board seat because that person can't stay in the room. So think about it ahead of time, come up with a board policy on that. Lead director concept. The IRS does not require board leadership to be independent. However, we've seen, maybe you've seen, situations where the board chair is not independent. Maybe the board chair is an attorney whose firm is doing $300,000 worth of business with your organization, and he's an owner. He meets the criteria for being an interested person. What do you do about that? Well, one idea is to create a lead director. So you would have to, obviously, someone would have to sit down with the board chair and say, you are going to be potentially conflicted on a number of areas, and perhaps we should have someone who would be a lead director in our bylaws. You see this probably in the for-profit realm a lot, where now over time, instead of having the chair and the CEO be the same person in the for-profit realm, there's now a lead director who's separate from the CEO. It's the same concept being utilized in this case if you have a situation where it's difficult and awkward. I have some other ideas as well about how to get ahead of that. All right, what I've been talking about so far are specific practices around conflict of interest and independence. And now I want to suggest that you can save yourselves a lot of grief if you really, at the very beginning of bringing someone on as a board member, talk to them about how it is that you as a board approach conflict of interest and independence. So for instance, as you're sitting down talking to a potential board member, educate them all about what is it that you have in place for your conflict of interest policies and procedures. How do you define independent directors? Which committees do you allow the independent directors to serve on and which don't you? And this would be especially important for organizations who are healthcare organizations. At least my experience is organizations with physicians in them who want to serve in governance often do not understand this whole issue of conflict of interest and independence. And they do not get the fiduciary duties piece that Tracy talked about ahead of time. They don't understand that if they're the chief of the medical staff and an ex officio voting member of the board by virtue of their role, that they're now a fiduciary. They have legal responsibility to this organization, and it puts them in a very different category. And I think that it's a disservice that we do to potential board members if we don't, from the beginning, explain, this is what you're signing up for. I hope you are okay with that. Another important piece during this recruitment and selection period is the governance committee, at least I would recommend the governance committee, should do an honest evaluation or assessment of what percentage of your board really is independent. And you might be surprised, because if you really start thinking about all those criteria that Tracy was talking about, what amount of business is being done by each organization, whether or not someone's an employee, etc., you may end up with a very narrow majority. And although that will probably work in terms of some of the strict regulation here, if you look at the court of public opinion, if someone were out there saying, is this board really independent? And if, heaven forbid, all of those relationships were on the front page of the newspaper in your local area, it might not look so good if just barely half of your members are independent. And by the way, I'm not kidding about that. I can state Louisville, Kentucky, and also there's a small town in North Carolina where the editor of the newspaper intentionally went out and looked on the 990 form and printed on the front page all of the relationships between all of the board members and the entity on whose board they were serving. Very embarrassing. I'm sure you don't want to be in that position. So figure it out ahead of time, and then do all your recruiting and selection based on both the disabling guidelines and what percentage of people you already have who are independent, and figure out, if we're going to bring someone onto the audit committee, we need to make sure that we're balancing everything. There are a few other areas that may or may not at first seem connected, but I want to raise them because I think they are. Non-representational governance composition. Sometimes we find that organizations get into a situation where they have non-independent members because there's something in the bylaws that says that certain people get to sit on that board no matter what, by virtue of their role. So it might be because they are the chair of another corporation that's part of your corporation. Maybe it's because they're an auxiliary entity. Maybe it's, as I mentioned earlier, if you're a hospital or health system, it's a physician who's chief of staff. The whole concept of using representational governance, in other words, this seat on the board is for this person, this seat is for this person, this seat is for this person, goes against the grain of having a highly effective board that is carefully chosen based on the skills and competence and independence that you need. And so I can talk later if you'd like about this whole idea of representational governance, but that's another thing to think about, is if you're using any sort of, this chair is saved for a person with a certain type of experience or a certain role, you might want to revisit that, because it can get awkward if you have someone who is the chair of the, an affiliate who automatically gets to sit on your board and that person's not independent. It gets a little tricky. Terms and term limits, another tool or technique. I know there's a lot of opinions about whether to have term limits. I think that it's another tool that helps you deal with awkward situations. So if you have 3-year terms and 3-year term limits, then at the end of the first term, it gives you a chance, the governance committee, to sit down with a person who may, in fact, have a lot of potential conflicts or who may not be independent, and just have a conversation. Is this the right thing for you to be doing now? And look at how many times you had to recuse yourself. Is this really going to be a good way for us to fill this seat on the board? And is this really a good thing for you as a person if you have to leave all the time? So it's a tool. Competency-based governance, I've made a slight reference to this before. You may know that there's a movement in governance